Hey guys, so we can now catch up with the case against Brian Freedman and his law firm from Clemence Urey, who was the widow of Travis Flores, and he is bringing the action on behalf of the estate of Travis Flores. Most of Clemence Urey's claims against Freedman and his law firm have been dismissed. So this is a fee motion from Freedman. Let's go through it. Although it says 83 pages, most of that is, it's only actually 14 pages is the actual motion, so it's not too long. Alright. To the Honourable Court, all parties and their counsel of record, please take notice that on July 27th, 2026 at 9 a.m. or as soon thereafter as counsel may be heard in Department 507 of the Los Angeles Superior Court. I'm not going to read the address. Defendants Brian Freedman and Lina Freedman will and hereby do move this court for an order under California Code of Civil Procedure section 425.16C and the California Rules of Court, Rule 3.1702B1, ordering plaintiff Clemence Urey individually and as the administrator of the estate of Travis Michael Flores to pay attorney's fees and costs in connection with defendant's partially successful special motion to strike plaintiff's complaint in this action, plus further fees and costs associated with this motion for a recovery of fees and costs. Defendants bring this fees motion because they are prevailing defendants under Section 425.16C, which mandates that a prevailing defendant on a special motion to strike shall be entitled to recover his or her attorney's fees and costs. The amount incurred to date for which defendants seek recovery is $53,520.93. This represents 75% of the fees incurred to litigate the anti-SLAPP motion, which reflects defendant's partial success on that motion, plus $13,927.50 in additional fees to prepare this fees motion, and $1,479.30 in costs. Really? It's nearly $14,000 to prepare one motion? Defendants also intend to seek additional fees and costs that they anticipate in preparing reply papers in support of this fees motion, plus fees and costs associated with a hearing on the fees motion. Defendants will detail such fees and costs in a supplemental declaration to be filed with their reply papers. This fees motion is based on this notice, the attached memorandum of points and authorities, the concurrently filed JASI declaration, and exhibits 1 through 4. Defendants previously filed anti-SLAPP motion and all supporting papers, all pleadings and documents on file in this action, and such further evidence, argument, and judicially noticeable material as may be presented at the hearing on this fees motion. Defendants respectfully request that this court order plaintiff to pay defendants $53,520.93 plus fees and costs in connection with reply papers in support of this fees motion and a hearing on this fees motion. Okay. Oh, there we go. Right, so introduction. In 2021 and 2022, defendants Brian Freedman and his firm represented Travis Michael Flores in a copyright and idea submission case against Justin Baldoni, a well-known director. That case resulted in a walkaway settlement, after which Flores passed away. Defendants later represented Baldoni in an entirely different and highly publicised litigation against Blake Lively, a well-known actress. Following public statements Freedman made in connection with the Lively-Baldoni litigation, referencing the earlier Flores litigation, Flores' surviving spouse and the administrator of Flores' estate filed this lawsuit individually and as administrator of Flores' estate, alleging 5 causes of action against Freedman and Liner. In response and in defense of their free speech rights, defendants filed a special motion to strike the complaint pursuant to Code of Civil Procedure, section 425.16. The anti-SLAPP motion was largely granted. Most of the anti-SLAPP motion targeted the 4th and 5th causes of action for defamation and invasion of privacy. That portion of the motion was granted. A lesser portion of the anti-SLAPP motion targeted slivers of the first 3 causes of action for breach of contract, breach of fiduciary duty, and legal malpractice. That portion of the anti-SLAPP motion was denied. Based on this outcome, defendants submit that approximately 75% of their anti-SLAPP motion was successful. Under California's anti-SLAPP statute, a prevailing defendant on a special motion to strike shall be entitled to recover his or her attorney's fees and costs. Defendants prevailed on their anti-SLAPP motion. They are therefore entitled to an award of fees and costs associated with the successful portion of that anti-SLAPP motion and this fees motion. JVC's hourly fees associated with defendants' anti-SLAPP motion were $50,819.50. Defendants seek 75% of their fees for the anti-SLAPP motion, along with $1,479.30 in costs incurred to date. In addition, the fees and costs associated with this fees motion so far amount to $13,927. Defendants therefore presently seek to recover $53,520.93. If Zuri opposes this fee motion, then defendants will be entitled to additional fees and costs associated with preparing reply papers and preparing for and appearing at the hearing in this fees motion. Relevant factual and procedural history. Flores' copyright lawsuit against Baldoni and others. In July 2021, Flores engaged defendants to represent him in a copyright infringement and idea submission case alleging that Justin Baldoni and others had used Flores' idea for a movie entitled 3 Feet Distance to develop and produce the film 5 Feet Apart, which Baldoni directed. In the Flores litigation, the defendants produced documents in support of their defense that they had independently created 5 Feet Apart, and defendant Ambry Genetics, through which Flores had alleged Baldoni had gained access to Flores' idea, moved to dismiss the case. In March 2022, before the court ruled on Ambry Genetics' motion to dismiss, Flores entered into a non-confidential settlement agreement with all of the defendants in the Flores litigation to settle the Flores litigation without an admission of liability by any party. The Flores litigation was dismissed on March 29, 2022. Flores passed away over 2 years later on May 23, 2024. Baldoni's entirely separate litigation with Lively over 2 years later. Freedman first spoke with Baldoni more than 2 years after the Flores litigation was dismissed, and Baldoni engaged Freedman to represent him in late December 2024. On December 31, 2024, 2 years and 9 months after the Flores litigation was dismissed, actress Blake Lively sued Baldoni and others in federal court in New York, alleging various claims related to the production of Baldoni's film It Ends With Us. 2 weeks later, Baldoni and Wayfarer, represented by defendants, filed a countersuit against Lively and others, alleging claims for extortion and defamation among others. Together with Lively's lawsuit, the Lively-Baldoni litigation. The Lively-Baldoni litigation garnered worldwide press attention largely because of Baldoni's and Lively's celebrity status. As part of this press coverage, various outlets began reporting on Freedman's prior representation of Flores adverse to Baldoni. In response, Freedman issued a statement clarifying the prior lawsuit against Baldoni. I learned that they did absolutely nothing wrong and that there was no liability on their part whatsoever. As a result, the case was resolved without any liability on Justin's or Wayfarer or any other defendant's part. Freedman continued. This only further confirmed to me that Justin and Wayfarer are exceedingly honourable and highly ethical. The media statement did not mention Flores. This action and partial grant of anti-SLAPP motion. In October 2025, Clement Ciori, Flores' surviving spouse and administrator of Flores' estate, filed this action against Freedman and LFTC, alleging 5 claims. 1. Breach of contract. 2. Breach of fiduciary duty. 3. Legal malpractice. 4. Invasion of privacy. And 5. Defamation. As the court's order on defendant's anti-SLAPP motion explained, the complaint alleged 3 general bases for Freedman's liability across the 5 causes of action. First, the complaint alleged that Freedman committed malpractice, breach of contract, and breach of fiduciary duty in the original representation when Flores was Freedman's existing client. Second, the complaint alleged that the media statement and similar statements to the press constituted a breach of Freedman's duties as an attorney to Flores as a former client. And third, the complaint alleged that Freedman committed torts going beyond his duties as an attorney, specifically that he defamed Flores and invaded his privacy by issuing the media statement and similar press statements. Defendants responded to the complaint with an anti-SLAPP motion. The anti-SLAPP motion did not challenge the first basis for alleged liability, i.e. Flores as a then current client. The court agreed with defendants that the media statement and Freedman's similar statements to the press in connection with the Lively-Baldoni litigation and referencing the Flores litigation are clearly and obviously protected by the anti-SLAPP law at the first step of the anti-SLAPP analysis, because they were statements made to the media on a matter of intense public interest that clearly contributed to that discussion. The court also agreed that statements to the media were within the ambit of the anti-SLAPP statute as to the first 3 claims at step 1 of the anti-SLAPP analysis, but held that other alleged actions were not. At step 2 of the anti-SLAPP analysis, the court held that the defamation and invasion of privacy claims lacked merit entirely and thus failed completely. The court rejected defendants' arguments that the media statement could not form the basis of portions of the breach of contract, breach of fiduciary duty, and legal malpractice claims. An award of attorney's fees and costs is mandatory where a defendant is successful on an anti-SLAPP motion. Defendant's anti-SLAPP motion resulted in 2 of the complaint's causes of action being stricken entirely, thereby achieving a substantial portion of the anti-SLAPP motion's aims. The California Supreme Court has held that any anti-SLAPP defendant who brings a successful motion to strike is entitled to mandatory attorney's fees. The award of attorney's fees to a defendant who successfully brings a special motion to strike is not discretionary but mandatory. As the Supreme Court clarified in Ketchum, the mandatory fee award is not limited to fees associated with the special motion to strike, but also includes attorney's fees associated with filing and litigating a fee motion like this one. The fee award is a central component of the anti-SLAPP law. The fee shifting provision is intended to discourage such strategic lawsuits against public participation by imposing the litigation costs on the party seeking to chill the valid exercise of the constitutional rights of freedom of speech and petition for the redress of grievances. The legislative aim in including the attorney fee provision was apparently to strengthen enforcement of certain constitutional rights, including freedom of speech, and petition for redress of grievances by placing the financial burden of defending against so-called SLAPP actions on the party abusing the judicial system. Anti-SLAPP fee shifting also encourages private representation in SLAPP cases and empowers defendants to mount full defences. By requiring SLAPP plaintiffs to bear the costs, the anti-SLAPP statute adequately compensates prevailing defendants for the expense of responding to a baseless lawsuit. A defendant need not succeed in striking every challenged claim to be considered a prevailing party within the meaning of Section 45.16. Rather, a defendant who partially prevails on an anti-SLAPP motion is entitled to recover attorney's fees and costs as a prevailing party unless the results of the motion are so insignificant that the defendant did not achieve any practical benefit from bringing the motion. A defendant's lack of success in striking some claims is relevant only to the amount of fees awarded, not to the defendant's right to recover fees. Mann provides guidelines for determining the amount of anti-SLAPP attorney's fees that should be awarded to partially successful defendants. As with any anti-SLAPP fees award, courts utilize the lodestar method, in which a court begins by multiplying 1. The reasonable hours spent in connection with the anti-SLAPP motion by 2. The reasonable hourly compensation of each attorney. If, as here, the work on the successful and unsuccessful claims substantially overlaps, the court considers the defendant's relative success on the motion in achieving his or her objectives. In assessing a defendant's relative success, the court should consider several factors, including 1. The extent to which the defendant's litigation posture was advanced by the motion, 2. Whether the same factual allegations remain to be litigated, 3. Whether discovery and motion practice have been narrowed, 4. The extent to which further litigation expenses and strategy were impacted by the motion, 5. The experience and ability of the attorney, and 6. The novelty and difficulty of the issues. Defendant's anti-SLAPP motion was at least 75% successful in striking the claims and portions of claims it actually targeted. As the court acknowledged, the complaint alleged 3 general bases for Freedman's liability across the 5 causes of action. 1. Freedman's alleged malpractice, breach of contract, and breach of fiduciary duty when Flores was Freedman's existing client. The first basis of alleged liability, which was not targeted by the anti-SLAPP motion at all. 2. Freedman's alleged breach of his duties to Flores as a former client. The second basis of alleged liability, which was only partially targeted by the anti-SLAPP motion. And 3. The tort claims for defamation and privacy and invasion of privacy. The third, which was the focus of the anti-SLAPP motion. The fact that allegations pertaining to the first basis of liability remain in the case has no bearing on the defendant's percentage of success on the anti-SLAPP motion, because defendant's anti-SLAPP motion did not attack that basis for liability at all. The anti-SLAPP motion targeted just the second and third basis for liability. Defendants completely prevailed on their anti-SLAPP motion's attack on the third alleged basis for liability, the defamation and invasion of privacy claims. Defendants did not prevail on the portion of their anti-SLAPP motion that targeted the second basis for liability, but this accounted for just a small portion, roughly 25% of the anti-SLAPP motion, i.e. relatively small portions of the first, second, and third claims targeted by the anti-SLAPP motion. The 75% that defendants seek under these circumstances is amply supported by the applicable case law. The anti-SLAPP motion also had a meaningful effect on defendants' litigation position by eliminating an entire set of claims and damages to be litigated. At their core, the first claim for breach of contract second claim for breach of fiduciary duty, and third claim for attorney malpractice allege that defendants breached professional duties they owed to Travis Flores as a current and former client. The fourth claim for invasion of privacy and fifth claim for defamation, by contrast, focused on the impact that Freedman's media statements allegedly had on Flores' purported post-mortem reputation and privacy interests, which are not cognizable, and on Suri himself in his personal capacity. By eliminating these two causes of action, defendants successfully eliminated significant factual allegations and associated discovery from the case, particularly as to damages, which will result in a meaningful reduction in litigation costs going forward. Defendants' attorneys' fees are reasonable and should be awarded as requested. Because defendants are the prevailing parties and are entitled to recover fees and costs under the mandatory fee shifting provision of Section 425.16c, the only issue for the court to consider is the reasonableness of the fees and costs sought. In Ketchum, the Supreme Court held that absent circumstances rendering the award unjust, an attorney fee award should ordinarily include compensation for all the hours reasonably spent, including those relating solely to the fee. The trial court has discretion to determine whether fees under Section 425.16c were reasonably associated with the successful anti-SLAPP motion. In making this determination, the court may and should consider the nature of the litigation, its difficulty, the amount involved, the skill required, and the skill employed in handling the litigation, the attention given, the success of the attorney's efforts, his learning, his age, and his experience in the particular type of work demanded, the intricacies and importance of the litigation, the labour and necessity for skilled legal training, and ability in trying the case, and the time consumed. In Church of Scientology, which was decided 30 years ago, the Court of Appeal weighed these factors and affirmed the trial court's award of fees totaling over $130,000 to the prevailing anti-SLAPP defendant. Here, the relevant factors all reflect that defendants' fees are reasonable and should be awarded in full. Defendants' counsel's rates are reasonable. Defendants' counsel, the law firm Jassy Vick Carolan, charged reasonable rates for the defense of this lawsuit. JVC is widely recognized as a leader in the field of First Amendment litigation. It is ranked both nationally and locally as a Tier 1, top-tier firm in the fields of media law and First Amendment litigation by Best Law Firms, and is recognized for its work in media and entertainment litigation by Chambers and Partners. The JVC attorneys handling this matter for defendants were Jean-Paul Jassy and Jeffrey Payne. Mr. Jassy is a founding partner of JVC. He graduated from the University of Southern California Law School in 1999 and has been practicing law for nearly 27 years. Several industry groups have recognized Mr. Jassy as a leader in First Amendment litigation, including Chambers and Partners and Best Lawyers. He is listed in Band 1 for First Amendment litigation in California by Chambers and Partners. He has been named Lawyer of the Year in Los Angeles 6 times in the fields of First Amendment law and First Amendment litigation by the Best Lawyers in America. Throughout his career, Mr. Jassy's practice has emphasized First Amendment litigation, and he has litigated dozens of anti-SLAPP motions throughout Southern California, as well as First Amendment cases in the United States and California Supreme Court. Mr. Jassy has also taught full-length courses on First Amendment law at the University of Southern California Law School, the University of California, Irvine School of Law, and Southwestern University School of Law. Before co-founding JVC, Mr. Jassy worked at other law firms, including the large law firms Davis Wright, Tremaine, Loeb and Shepard, Mullen, Richter and Hampton. and was a founding member of Bostwick and Jassy, a boutique firm that was ranked as a Tier 1 top-tier firm in media and First Amendment law by Best Law Firms. Mr. Jassy's discounted allocated hourly rate on this matter is $795. JVC of counsel Jeffrey Payne graduated from Loyola Law School, Los Angeles in 2011. After graduation, Mr. Payne clerked in the Central District of California and on the Ninth Circuit Court of Appeals, worked for nearly 5 years as a litigator at Munger, Tolles and Olson in Los Angeles, and spent a year in-house in business affairs at Showtime Networks before joining JVC, where he has practiced for more than 5 years. Mr. Payne has litigated multiple anti-SLAPP motions at the trial and appellate levels. Mr. Payne has also been listed in Super Lawyers as a rising star every year since 2022, and he is currently an officer in the Los Angeles Copyright Society. Mr. Payne's discounted allocated hourly rate in this matter is $650. JVC entered into a modified contingent fee with defendants by which JVC billed defendants a $50,000 flat fee for preparing the anti-SLAPP motion papers and appearing for the hearing. Defendants agreed, however, that if the anti-SLAPP motion was successful, JVC could pursue and retain its full hourly rate as a fee enhancement to reflect the risk that the anti-SLAPP motion might be denied. And JVC agreed to absorb the loss of its billable time if the motion was not successful. For this fees motion, defendants agreed to a $10,000 flat fee with the same modified contingency fee arrangement for enhanced recovery in success. Thus far, the total hourly fees and costs JVC seeks associated with defendant's anti-SLAPP motion and this fees motion is $53,520.93, which includes 75% of the $50,819.50 in fees incurred for the anti-SLAPP motion, including the moving papers, reply and hearing. California courts have expressly upheld a prevailing anti-SLAPP defendant's right to recover their counsel's full hourly rate in the context of modified contingency agreements like the one defendants agreed to with JVC in this case. In Dowling v. Zimmerman, for example, Zimmerman agreed to pay her attorney a $1,300 retainer provided that the attorney would collect his attorney fees from her under the anti-SLAPP statute if the defendant prevailed on her special motion to strike the SLAPP complaint, but would absorb the loss of his billable time if the court denied the motion. The court rejected Dowling's argument that Zimmerman should have been limited to the incurred amount of $1,300 and affirmed the trial court's reduced hourly fee award of $9,300. The Supreme Court has explained that contingency fee enhancements like these are intended to compensate for the risk of loss, generally in contingency cases as a class. Ketchum and rejected the notion that such enhancements result in a windfall to attorneys representing SLAPP defendants. Given their length of time practicing law, experience and expertise, defendants' counsel's discounted allocated fees are reasonable and well within the rates charged by peers in California and the Los Angeles legal community, in particular for anti-SLAPP work. Los Angeles area courts often rely on the real rate report to determine the reasonable rates of attorneys. The 2022 Real Rate Report for Litigation Matters in Los Angeles identifies the following hourly rates. Okay. Well, there's the fees. I won't read them, but It's for, kind of each level of attorney, median, and third quartile. The hours that defence counsel spent were reasonable. So it's not just that the hourly rate has to be reasonable, it's the amount of hours have to be reasonable. So it's good to think of, this is kind of what is going to happen if Judge Lyman does grant Lively, or in Texas with Judge Wallace. If Lively is granted attorney's fees and costs, this is the kind of stuff that, it will have to be justified. But the hourly rate was reasonable, and the amount of hours spent was reasonable. Okay. The time that defence counsel spent on the case was also reasonable. First, defence counsel contemporaneously kept their time spent on this matter, as reflected in attached time records and the Jesse Declaration. The records are redacted as necessary for privilege and relevance. While an award of attorney's fees may be based on counsel's declarations without production of detailed time records, defendant's counsel has produced itemised time records here. Verified time records, like the ones defence counsel attach here, are prima facie evidence the costs, expenses and services listed were necessarily incurred. Mr. Jassy spent 33.1 hours and Mr. Payne spent 37.7 hours litigating the anti-SLAPP motion, and 4.6 hours and 15.8 hours respectively to date litigating the fees motion. Second, the attorney's fees are reasonable in light of the nature of this lawsuit, which involved 5 causes of action based on statements made and conduct taken in 2 different cases apart from this one. Defendant's anti-SLAPP motion required investigation and review of those underlying proceedings and marshalling substantial evidence, 2 declarations and 10 exhibits, to respond to the causes of action alleged against them. Defendants had to brief the anti-SLAPP motion and prepare a thorough reply in support of that motion when Sciorri chose to aggressively oppose it. As the California Supreme Court has stated, the amount of time necessary to litigate an anti-SLAPP motion typically lies in the plaintiff's hands. Having litigated the matter tenaciously, the plaintiff cannot be heard to complain about the time necessarily spent by the defendant in response. Third, defendant's litigation strategy was efficient in resolving a significant portion of the lawsuit quickly. From the outset, JVC assessed the deficiencies in the complaint, invoked anti-SLAPP law, and filed a meritorious anti-SLAPP motion that efficiently eliminated 2 claims in their entirety, along with the factual allegations and discovery that come with them, within a reasonable time and at a reasonable cost. Fourth, the hours that defence counsel spent litigating the fees and costs awards sought are well below other anti-SLAPP fee awards that have been affirmed by courts, including in decisions going back to 10 to 15 years when most attorneys' hourly rates were significantly lower than today. All of the above makes clear that defendant's current request is well within the range of reasonable fee awards for the successful defence against a significant portion of the complaint with an anti-SLAPP motion. Conclusion: defendants respectfully request that the court grant this fees motion and award them $53,520.03, 75% of JVC's anti-SLAPP fees, plus fees for this fees motion and costs to date. Defendants also seek additional fees and costs for any reply brief and the hearing on this motion. Okay, so that's that. I will keep an eye on the opposition because I'm expecting an opposition. I do know though that Clarence Sciorri has filed to appeal. Appellant's notice designating record on appeal. So there's not much here at all. filing the transcript, which is part of the process. Let's have a look. I mean, there's not too much I can tell you here on all this. But they are designating record on appeal. Got something else here? Right, yes. So, notice of default for designation. Okay, let's have a look at this. To appellant, your appeal has been placed in default for failing to designate what documents and all proceedings, if any, are to be included. In addition, I don't know if they failed to deposit the $100 or to serve. This was filed, when was this filed? May 14th. There is nothing on the system to say that they have complied with this within the 15 days after this notice is sent. So I will see what the outcome is, whether the appeal has been referred to the Court of Appeal for dismissal. But basically, Clemenziori filed a notice of appeal to designate record on appeal, but it looks like a notice of default has been sent because he's failed to designate what documents and all proceedings, if any, are to be included in the record that will be sent to the Court of Appeal. And from when I was looking at the docket earlier, I couldn't see that he had corrected this within the time frame. But I will keep an eye on that, and I will obviously cover that, and let you know the outcome. I'm obviously waiting for the opposition to this as well, if one is coming, or whether the judge grants it. Alright guys, thanks for watching.